in the session on Paris Agreement and India's legislation. I don't want to go too deep into that as you've done, and rightly you've done a good amount of research. I congratulate you on that, and thank you for sharing it. There is no such thing as international environmental law from below. You get from the top, IEL, what the treaties are, what the legislations are, what the Supreme Court has done, but on the ground, whether there is international environmental law, so forth, is a big question. You are right about PESA. I can add a number of other provisions of the Constitution. The 5th and 6th schedule of the Constitution are very important, and they schedule areas have the power to determine which laws will apply to them. There is the famous Coca-Cola case in Kerala, where the municipal the council were refused permission. The Niyamgiri case, the forests and rocks were being felled by Vedanta. So there are progressive developments. The advantage of studying international law, environmental law, international law from above, is to get a glimpse of what nations have agreed to or are bound by, okay, whichever, are bound by customary law or agreed to by way of treaty. The jurisprudence does not tell you what's happening on the ground. So how do we construct environmental law, IEL, from below? Is a great question. And that's what Constitution some way speak to the below, that below, by giving them veto. Whether there should be referendum, giving people a veto over legislation not merely of the state but of parliament. That is your 5th schedule. The 5th schedule, the Hill Council, any Hill Council in the scheduled area can say no to legislation duly passed by the state or by Parliament of India. Such a provision does not exist anywhere else. That's what I'm saying. But how far it works, and that's one of the great problems with uniform civil codes, conceived in a majoritarian way. Many Naga or Tripura council could simply say no. And that's why the directive principle rightly says takes an endeavor to secure a UCC. I don't want to go there. But this is one example of complete autonomy of the people concerned to choose the law by which they are governed. Whether there should be referendum or not is a very good question. There are countries with referendum system, and you mentioned one. There are many countries. Whether there should be environmental referenda instead of environmental clearance is a subject of some importance. Assuming the referendum would constitute a higher law, but you have to study recently the 2 judgments given in England on Brexit, British exit, by the High Court. The last decision was the High Court, and while it did not go into the question of British exit, it seemed to say that it said that going through the route of Parliament is necessary. You cannot simply withdraw from a treaty by executive order. And British Parliament recently overwhelmingly endorsed the referendum and decided to quit, as you know from newspapers. So it is, question is whether referendum should prevail or Parliament mediating the referendum should prevail. And this is a very big question. What type of referendum procedure do you want in your Constitution? And do you want an environment? That's a good idea. That's a very good idea. It will stop many of the evils that we are facing. How do we structure it? This could be one of your papers for this class. How can we amend the Indian law to be more environmentally friendly rather than being environmentally visually challenged? That's the question. Is Indian law environmentally blind, as it were, or is it environment conscious? notwithstanding the Samta decision and many other decisions that court has given. That's a good subject by itself. I'll come to that. But I think you touched on a very important case of IEL, or International Environmental Law. I'll simply say IEL from below. What people expect. And in fact, the Guardian article was a long discussion on an author called Melandorf. And Melandorf proposes, if you read the article, when you read the article, that these poor people should be permitted to emit as much as they like, emit carbon, greenhouse gases. Now, Melandorf, of course, there's a mischief in giving you this article. Let me be very clear. This is written by non-lawyers. This is written by philosophers. It's a review of two important books. There are also a Melandorf book and Demison's book, a review article. Of philosophy writing by philosophers. And therefore, this is not a legal article. And you can gather something about legal articles. And I don't know how many of you are in habit of reading philosophical articles, whether they are prescribed in your courses or not. But they require a different kind of reading than a legal article. I won't go into it. So there is that reason, one of the many reasons why I gave this article. The other reason why I gave it to you was the notion of Gardner appears there of a perfect moral storm. So it coincides with or does not coincide with the Duryodhana epistemology that I mentioned last time. And third reason I gave you this article was Melandorf. Melandorf said a just admission is that which is done by poor people of the world. Now, India, is it poor or not? Or they are poor in India? Poor in China, or China being poor? These are leading countries which are making a lot of noise, and rightly so, justly so. Or Nigeria poor? Is the Nigerian state poor, or Nigerian people living in Niger Delta who is poor? So one question is, are you talking of BPL? BPL, you know, below poverty line, that is used in India and World Bank and India, everybody uses it. Are you talking of individuals or collectivity? Should international law talk about individuals directly? Does international law speak to individuals? Well, in human rights, it does. In human responsibility, it does. In case of terrorism, the Security Council can impound an individual's money in the bank, like in Zurich or some part of Switzerland. So there are special resolutions of Security Council after terrorism where you can proceed against, but only individual, not the nation, not the clan, not the everybody else, not the collectivity. So this, you read as a lawyer, a would-be lawyer, read this article, but it's a very important idea. In an unjust world, what constitutes justice? That's the question that these philosophers argue. Or to use Demison's idea, Demison is the first author of the reviews. Demison says climate change is a very wicked problem. It's not a moral storm, as Gardner says. It is simply a wicked problem. And this article gives you 7 criteria, or Demison himself gives 7 criteria of what is considered wicked. I won't go into it. So when you use the word wicked, apart from being a pejorative, it's an ethical idea. And there's certain characteristics, and you must be aware of it. So I leave it to you. Have a great time with Gardner. He will be with us on many occasions. I've used this article a number of times. And today I want to talk about law. basically international law, and basically international environmental law. Now I'm told that some of you are attending a course on international environmental law, and therefore you know more than I could ever know. So it is carrying MIC to Bhopal victims in that case. It's carrying post to Newcastle. Pre-Anthropocene trace or post-Anthropocene trace carrying MIC to Bhopal. So you're doing this, though you know a lot of it, and I apologize in advance to you. But maybe in my way of putting it is slightly different than you might use in IEL. IEL is International Economic Law. IEL is International Environmental Law. But what if we had a competitor in law and development program, and the competitor was IEL, International Economic Law. So my students are now doing international economic, taking international investment law. Selin Tan, who did a remarkable study of World Bank, Selin is now teaching IEL, international investment law. International economic law, one thing is many things, WTO, and so on. So, can we say IEL is the same? International economic law and international environmental law. Are they the same or are they different? I mean, they happen to share the same verbiage, same shelter, IEL, IEL. I'm talking about international economic, environmental law. But I think when you critique the basic ideas, like permanent sovereignty over natural resources, which is where it all started, UN resolution, where the decolonization of international law started, whether you are doing with PSNR, permanent sovereignty over natural resources, whether are you dealing with the idea of PP, I call it, because I want to say breadth, precautionary principle, PP. And easy to say BP. Or whether doing with SD, which is sustainable development. In all these areas, you're dealing with the idea of IEL, IEL 1, international, IEL 1 or 2, I don't know. But you're dealing with, to remove the confusion with economic law, I say N law, environmental law. And we seem to think that it is different from the other idea of why. Why is international economic law different from international environmental law? And to what extent it is different? This is one of the things that might interest you, and you might want to look at this in your article, essays, or course, or generally, if it interests you. I won't go into this because there is no time. It will be clear, however, from the critique of the three principles I have mentioned and the DO principle, precautionary principle, the permanent sovereignty over natural resources, precautionary principle, sustainable development, and DO principle. I won't be able to go up to DO principles at all in the talk, but these are the four instruments that base international N law, to distinguish from IEL. So the question that first of all arises, and I put it in the language of Hans Kelsen, is there a good norm, a basic norm of N law? Is there a basic norm for N law as such? That's the first question. And that question has become very important. It was always important, but it became important now. And why it is become important now is because of Anthropocene, which is a reality, which cannot be denied. So the question is a long quotation. I was hoping to have slides, so I put slide, ignore it. There is a note, turn off lecture notes. I put a long quotation which says we have crossed 3 out of 9 planetary boundaries already. We have this article by Rockstrom, and he knows what he's talking about. 3 threshold values have been closed: climate change, biodiversity loss, and the nitrogen cycle. Out of 9, we have already crossed 3 thresholds. And we might cross more if global warming and climate change or Anthropocene continue. So that the sovereign question is not something called an law. The sovereign question is how far the so-called N law has helped people to cross the 3 boundaries already, and how to stop N law from crossing the remaining boundaries. That is the question. The question is not about environment. What is the good norm of environment law? A good norm of environment law, N law, could not be, by definition today, crossing all planetary boundaries. So then there is no planet. There will be no life, human life. There will be no species life. How to prevent that from happening? So in a sense, the question we can do formulate in many ways. One is how to use IEL or N law in Anthropocene. Era is now upon us. Or you can say, how do we reimagine N law? Or how do we retool N law, that which we know as N law? How do we recast it? How do we tell different stories by which this thing called Anthropocene can be arrested? That's the idea. Or how do we mutate it? Is the question. How do we assume that this body of law exists and has a sanction of international treaty? How do we mutate it, change it here and tweak it in favor of avoiding Anthropocene? You can ask this question, therefore, in half a dozen different ways. And each of the ways of asking the question will guide your way of answering it. But the way you ask the question is terribly important, as you know. The way you ask the question will determine what response you will give. And my favorite example currently is our beloved Prime Minister. The way he asked the questions on telephone about demonetization, 93-95% of people supported it. The way, if you ask the question in a different way, there will be no support. The way you ask the question is very important. Restart, retool, reimagine, arrest Anthropocene, can environmental law, which was pre-Anthropocene, late Holocene environmental law, which is a product of 1950 40 years old field, late Holocene, merging into new era of Anthropocene. Can an old Anthropocene, late Holocene law be used at all for the Anthropocene? Or do we need to jump international environmental law altogether and start afresh? Each one of these ways of putting the question will give you a different insight. All right so far? I'll pause. If there are any questions or comments related to this, you can discuss it now. It's a good time. If not, then the Mark Meslin quotation. Now this book you must get, it's very cheap, but inexpensive. It's dated in 2007. He has written 2 books, Mark Meslin, and I already lost the climate change book. He's written another book on global warming. which are pocket books, very short introductions to the articles. So you can get it. But Mark Twain says Anthropocene is marked at least by one characteristic of anthropogenic harm. Taken together, humankind becomes so large and active that it now rivals some of the great forces of nature. And human beings, as a part of nature, become a threat to nature. Crisis of survival happens. And it happens today. So how do you relate this? And Maslin says somewhere in the book, this is and I quote him, this is a geological age of our own making. That is Anthropocene. The human beings have made survival impossible, or difficult, very difficult. For survival of the planet as a whole. So, question of good and wrong. You can ask the same question about good and wrong. Is it a threshold concern? Why should we ask it? Well, Kelsen said, good and wrong, as you know. You have studied Kelsen? My students in Delhi always pronounce Kelsen, not Amita, I haven't read, but many others. In Jurisprudence they wrote Kelpon, S-O-N. And pound, there were various variations. Pund, pound very early, pond. They were not typing this thing, they really thought they were talking about pond or pund or something else, anything else but pound. So I told the class, I said, Kelsen is no doubt somebody's son. But as he's not, his spelling is Kelsen, but they never understood that, and they took Kelpon. Because the guidebook, look, we had a guidebook in Jurisprudence. The guidebook in Delhi was called Dukhi, a guidebook. So in Jurisprudence class, I used to get up and say, what guidebook do you have do we have a guidebook? Come on, you can say it, I won't mind it. People use shortcuts to knowledge. Guidebook is a shortcut to knowledge. I say this to say to my class in Jurisprudence, the first 10 minutes, two things I used to say. One is, jo padega dukhi, wo hoega dukhi. Anyone who is dukhi will be miserable. I used to do it. And that's my only contribution so far to legal education, is to improve the quality of the guidebook. Because the guide Bala is a business, he's doing the business. And the way I set questions is through permission. I talk that way. The guide had to work very hard to understand the question and to answer it. So successive guides improved, and in fact they took, I cannot name them, help of some of my colleagues to write the guide. So to improve the answer. So over 10 years or 12 years, what is my contribution to Indian legal education? I improved the guidebook. That's very important contribution. And then other guidebooks have not studied, followed Dukhi and violated the copyright. So it might have able to improve legal education surreptitiously elsewhere. I don't know. I'm not studied the matter, so I can't say authorship of it. The second thing I used to say to my class was Carl Llewellyn, which is nothing to do IEL, who said in the first year, he said to American boys and girls, look at not what the judges say. Look at not what the judges say, but what they do with what they say. Llewellyn always said, don't just cast your eyes and hunt for the ratio and of the case, say no such thing as ratio. You look with what they do with what they say. That's studying law. That's the only way to study law. But that has nothing to do with IEL. And so, is it the threshold issue is, do we need a good norm at all? Kelsen said, you cannot have a legal system if you don't have a good norm. What is a good norm? He wrote a big, thick book which nobody reads, but it must be read, on United Nations Charter. And my colleagues from Africa could never get the English for their own English. So initially I had difficulty in the classroom. They said, something UN Charter. And I think the distinction between charter and charter is important. And it's difficult to draw. Very often it's idle charter. The charter is charter. And charter is charter sometimes. Now either church becomes the charter of the given kind. So it's very different. So it is, in Kelsen's idea, good norms is the foundation. It gives the unity to a legal system. A legal order, you can't curfew of others a good norm, beyond which there is nothing. So, is there a good norm? This is a misleading question, a fake question. Why don't you have autonomy of various branches, pollution, of water, of sea, marine pollution, air pollution, accidents, all hundreds of other things. Why unify this different area? Big question. So, I think there are 4 candidates, and which I want to discuss, are 4 good norms. And this I mentioned. It's precautionary, friendly. I was a PSNR, PC, SD, and so on. I'll discuss it. Before I do that, I want to ask you a general question. What's the environmental law prior to the last 40 years? And this is where your question makes sense. There was environmental law in India. Long time back. You didn't hurt the forest. You didn't light forest fires by dropping cigarettes into dry leaves. Okay. Aranyavas in Ramana, if you read Ramana, and you read Quran Sharif. Every religion prescribes certain duties, obligations to nature. Now what we have done, the classics of Western sociology of law in the 19th century, took law as a serious property of social structure. Whether it is Marx or Weber or Durkheim or Pareto or you name anybody. They took law as a central phenomenon. And that was an innovation in social science. That's why you can't have a division between pre-law and law. Law is central to sociology, to criminology, any logic. But they always said there are 2 other agencies of social control and social change. One they named as education, and other they named as religion. Religion and education and law go together to form a society. Now, we seem to be thinking that law does everything. That law is all part of religious superstition or whatever. If you are pseudo-secularists, they call it pseudo-secularists. What do you think? And religion is Brahman. It's a superstition. You believe in God and things like that. Yeah, a secular person. And therefore, you don't read the Quran Sharif, you don't read the Bible, you don't read the Jandavasta. How many people have read Jandavasta? After how often you've gone to a Parsi Gyari? You're not gone. So there are various religions which teach you, world religions as well as local religions, which tell you the value of environment. My point is very simple. My point is there was environmental law or environmental norm which were source of law, customary norms, in the ancient times. And we teach as if there was nothing before this or that teaching. That is wrong. We should not overplay the thing, but we should not deny that it exists. Second is, what is the relationship between law and social movement in terms of environmental law? We had Chitko Andolan in India, which are written, and you might have written, that women hug, and the feminism, women hug the tree from being felled, and they offer their back to the axis of contractors. And contractors went, now they say them in a different manner, in the name of development. I fought this them for 20 years, and it was not the court say all that. Just this foolish thing happened to India because of them. There's the first case in which he said, Professor, what have you hit me with? I'm not ready to read 3,000 pages. I said, say it. Don't even say it. Say has tremendous usefulness. So once the matter is said, and we in India believe and practice intergenerational justice, no? So I say then my son or my daughter will argue. It is a matter of generation. It's not settled in one generation. So I said, we only want to live well and say. He said, ask the government to do something about it. He wrestled with Sita. I had to study 9 months the Institute of Hyderabad. On top of there still is called Institute of Earthquake Engineering. Okay? They sent me the material on earthquake. And they said the study dam is not merely in fault area. Fault area, of course, many dams are built. But it is on the epicenter of the earthquake. In Japan, there are many dams that are built on fault area. You can't touch it. But you have dams here on the epicenter of the earth. And it is the world's largest rock-filled dam. So, we prevented it. And UP, it was then UP was a big state. We prevented it till Uttarakhand happened. And till then I used to argue for small states. I used to say, why not 50 states or 60 states? Why only 25 states, 20 states? But after Uttarakhand, it was passed and built with record speed. It's a small area, small state, one of the smallest states in India. And it was done by Bill State, not Babus from Uttar Pradesh. It was Babus from Uttarakhand who did it. So the local tribe, the people wanted them. And we are all them. If it does, heaven forbid, the whole of Indo-Gangetic plain will be affected. Will be no more. It will be as destroyed as Sri Sri Ravi Shankar destroyed the Yamuna floodplain. So, that brings me, in ancient times, there was, this is not saintly behavior. This is not what our scriptures say. We are alleged to be saints in Bangalore. I'm very angry, he destroyed it. And the beloved Prime Minister inaugurated the occasion. Why? In the name of culture. Now, therefore, environment, ancient environment, the prior law, custom, can often be said to conflict with culture or even religion. And I think we have to study environment law in the past in this sense. And that's my third point. I had just to scare his lordship as he then was, now the Chief Justice. I heard him, I was in the same podium, staring the same podium at one of the brother, what's his name? He was very angry. Swatanta seminar on environmental law. And Brother Care inaugurated. And he said, ladies and gentlemen, I did not know he was Keher, but he introduced himself, and I introduced myself. We were on the same podium. And he said, I'm not an international lawyer. I said, what an odd thing to say at a gathering of environmental lawyers, world gathering. And he said, I'm going to Chief Justice of Uttarakhand. And then he said something very important, which I want to convey to you, the sense of conflict between religion and environment. He said, I have a public interest petition before me, which challenge the taking a dip into the Ganges, small Ganges, not Prague, where everybody does. 100,000 people were taking a dip, and the public interest of social rationalization petition. There's a difference, but I won't go there. The social rationalization petition challenge wanted to prevent 1 lakh people from taking it. And he said, as the Chief Justice, what was I to do? Was I to care to protect religion, or was I there to protect environment? And this is coming from experience of being a Chief Justice of a state, that people take a look. I have not studied the petition, it is on my waiting list. I want to see what were the orders found. But as it happened, I know for sure the 1 lakh people did Pidupsi and polluted the river beyond measure. You can just imagine this placement of water, what happens to water when human bodies in such density enter a river. You really sort of mutate the environment, but it's considered holy. So it is important to look at the conflict, look at what existed in an ancient time, in medieval time, in Sharia, what Sharia says about environment. I don't think we know about what Kalam say about this particular thing, and so on. But we all begin our discourse with the famous report of Prof.Upendra called Our Common Future. Let us go to the first part of it, that is PSNR declaration. And there are, where is it on that? No. Nope. Try and help me. Oh, this has moved. It's not a touch thing. The page. Yeah, this is. Yeah. The PSNR. Thank you very much. PSNR, I can't do simple things. And here I'm talking about the most complex of things. But that's how it is. They are the principles laid down by this great declaration. And you need not worry, you need worry about it. It's a very important declaration. And 9 principles. And you'll get them in your notes and email tomorrow. But I want to draw your attention to the first principle, which is the right of nations and people to permanent sovereignty over natural resources. And that right is elaborated. So there is the first major step. The early 60s, the resolution by General Assembly was passed, and it has been frequently reiterated. This is the first time since the Charter of the United Nations you find reference to people. People-centered international law begins to happen. And it is this particular assertion of permanent sovereignty of over natural resources that actually in my friend Sundhya Pahuja has done a book called Decolonizing International Law. It's a very good book. It's a very good scholar at Melbourne. The decolonization of international law begins to happen. That's the importance of PSNR. And if you look at principle 9 of that particular thing, it binds states and international organizations. So it is not merely a declaration for the self-determining state, for the third world. It is a declaration that binds everyone because the declaration that we start the right of the people to permanent sovereignty. I won't go eloquent about this because there are lots of ideas in this declaration which nobody studies now. But PSNR declaration meant that no other state had jurisdiction or wisdom to interfere with me. No one state, it's also the beginning of principle of non-interference with the sovereign state and people. The sovereignty here belongs to state as well as to state in the sense of international law and people as constituting the state. So that's a marvelous. I cannot urge you more strongly to study the various articles of that declaration. It speaks about international cooperation. It speaks of free and beneficial exercise of the natural resources. It speaks of foreign investment, and it speaks, as I said, of international organization. Now, when you try and analyze this document, you'd find that these three rights, and I think they're there: access, right to access, right to withdrawal, right to manage, obvious enough. And each of these rights is very important. And the idea is no other state can tell you what India has to do or Saudi Arabia has to do. So this is enough. It is not merely, it is for a long while, Sandhya makes that mistake, the common mistake, for a long time. It was a declaration that was supposed to deal with nationalization. The nationalization was a big issue. Suez Canal was nationalized, Nehru renationalized, several undertakings, right to compensation articles, and he won the story. And the Western nations opposed nationalization. And every time nationalization was opposed, this declaration was cited by Tito, by Nalsar, by Nehru, by Sukarno, the non-aligned nation in the making. It is a very historic declaration. I'm concerned not so much with declaration. I'm concerned with not also with the rights that are mentioned. There can be more rights into that. I'm concerned with the deep issues that PSNR now raises. If you take what is known in literature as resource curse. Resource curse is that a nation is abundant in certain resources. Like Nigeria is in oil. And you heard of Ken Saro-Wiwa and his story. He argued for environmental, sustainable development or whatever. He also supported permanent sovereignty of natural resources. The fact that your resource itself becomes a curse. Oil is a curse to oil producing countries. A curse on human rights of people. And the proceeds from the oil are pocketed by the multinationals, and by the kings and the tyrants and the dictators. It becomes a curse. And therefore, the plunder and the predation by a few occur. Few are well-linked people internationally. I won't go into detail of how it occurs. I suppose you know it, or you will know it. And therefore, some sovereign states using PSNR use the idea of PSNR more or less a curse and peace. They use profligately, wantonly, in a manner suggesting predation. And there are two thinkers I mentioned here, Thomas Prograis and Liv Zenar. They've argued for a proposal of global justice, that you must check such people, you must not aid such governments, that Prograis, or this friend Leffler, what's his name, Zenar, says there should be a clean hand tax for every garden. So there have been proposals in the name of justice and people using the PSNR made against this particular thing. Whether these proposals will be accepted, they have been made by scholars, by publicists, whether they be accepted or not, is a major question of geopolitics. So how does geopolitics relate to environmental protection, to restore natural sovereignty over resources? The conflict, I think, between natural resources and anthropocene. Sovereignty over natural resources means right to emit as much in the atmosphere as the sovereign. You have a right to emit. Long time back, I wrote an article which I never published. It was done by judgment of a judge in Madhya Pradesh High Court, who sentenced 3-4 tribals for 3 years for collecting MFP, minor forest produce, which included bird dropping, tree dropping, and this was lying on the floor, and they collected it, and they were prosecuted, they were convicted. So I was very angry with the judge and the court, and with the law. And I wrote an article called, I asked, what is the sovereignty of bird dropping? So I said, sovereignty over shit. A critique of Justice Dixit's decision. And some friends from Bhopal told me he had a heart problem and so on, so to kill him to write the article. It was a very vitriolic article. I said, but that's what I feel like, but helping with Bhopal also. In a weak moment, I put in the pile of my unpublished writings, which are more published writings. So, because they're unpublished, nobody knows about them. But I worked out in a short, long life, that if they're published also, they don't read, people don't read, it's all right. It's an old satisfaction you write. Some people read, of course you all read, but outside. Bourgeois manners require a junction of the present company. I exclude you from other people in this respect. So I wrote the article. We still continue to exercise sovereignty over shit in Basta. Shit has a bird dropping is defined in the Act as minor forest produce. Fortunately, the bird shit is not used, the droppings are there. So, in a sense, there is a great conflict between livelihood and environment. With the conservation of livelihood, between culture and livelihood, and religion and livelihood. And how do you solve that conflict? But when you introduce Anthropocene, permanent sovereignty over natural resources means right to emit as much as you please. And this has come home today in Paris Declaration, framework treaty being discussed tomorrow, day after, I think tomorrow, I don't remember. will discuss it anyhow, in the guise of nationally intended contribution. NIDC. That is D, I don't know what it means. The formula is, and India has said we reduce it by 1.5, our emission. But you must reduce at least by 2%. No country is accepted 2%. Actually, the emissions have, in the air atmosphere are 400%, which is largest since the dawn of humankind. So it's already a critical matter, causing all the symptoms on the down. So PSNR and Anthropocene, I think, do not go hand in hand. But I'll be guided by it. If they do, let me know. Don't keep it a secret. To study the text of the text. I come to the second. And it is my only reference to the PP, precautionary principle. It is often touted as a grand norm, basic norm of IVL. And I've given you, I think, the principles. Yes. This is what Article 15 says. In order to protect the environment, the precautionary approach shall be widely applied by states. Where there are threats of serious or irreversible damage. I want that. You remember Nehru? You might have not remembered. If you read anything by Nehru, was heard any speeches, somehow internet also. Nehru used to say, and he spoke, he took hours to complete his speech. It's long-winded, but he used few words. And he stopped after some words. So he said in Hindi, I'll translate it for you. He said, Chale, there's a big pause. Chale means you walk. Then Nehru says, after 10 minutes, Chal se phir se gire. He fell down while walking. Again there was a pregnant pause. After 10 minutes he said, oh well, गिर के उठे. When he fell down, we rose. And after 10 minutes he said, उठ के चले. So you must stumble upon a word. You must came out and up. You must stumble upon a word. Don't use them precautionary. Don't use them mantras. But question them. चले, चल के गिरे, गिर के उठे, फिर चले. That's called reading. If you don't fall down, if you don't hurt yourself, if there is no pain in you, you're not read. If you're not stumbled, you're not read. I used to do a course on how not to read. I won't do it here. No. But that part. So in the principle, Rio Principle 15 says, where there are threats of serious or irreversible damage. Just Sri Sri Ravi Shankar said there were no threats of damage. Irreversible or not, God has spoken to him. What argument can you use? Bhagavan was terrible. What argument, if you are a believer, if you are not believer out of fault, if you are a believer, you accept it, his word. So Bhagavan speaks directly to this God. I don't want to offend your sensibilities, whatever, but your own good persons, I welcome to them. My wife is she goes to all saints and sadhus, and occasionally takes me along with them. I just met a godman in Pune. So I don't believe in the clap-trap, but some people do, and for them it's not a clap-trap. Bhagavan was, and he said God has spoken to him, what is his National Green Tribunal? What is Yamuna floodplain? The creator of this Srishti is hotline. अभी क्या कहेंगे? आप कौन सा लोग आएंगे? So this is, whether a thing is irreversible or reversible, who will decide? Leo does not tell you that. And no one tells you that, no treaty tells you that. where there are sets of serious effects of serious. Water is said to Yamuna plain, 12 plain, by 1 lakh people, 1 million people assimilated. Any, you don't have to be very secular to say yes, that is fact. You can be religious, you can recognize irreversible effect by receiver. But very often difficult. Lack of full-time respect shall not be. That's a very important thing. That if scientific opinion is divided, it shall not deter you from doing what? For postponing cost-effective measures to prevent environmental degradation. Cost-effective measures, what are they? What do you do if it costs more than is warranted? Rather than less. Would you still save the degradation? Is degradation and ending, avoidance of degradation ending this one? Or is degradation to be measured by the cost it could carry? That's the question. So I'm just illustrating this paragraph, there are many other interpretations. The whole thing, some people say, is bogus. I'm more measured, and I say it is indeterminate. Now what is different from being bogus and indeterminate is a matter I leave you to consider. What is hocus pocus and what is rational? I don't know the answer. I have an answer, but I won't tell you. No, I told you already. That has made the indeterminacy of the principle has made it very fashionable. Every country swears by it, speaking. But for some people, yes, there's a good norm of the PP is also a controlling declaration to be applied according to capability. If you are not capable, you don't apply for precautionary principle. And so on. PP has now become a part of international soft law. It has been reiterated so often since Rio conference. PP for precautionary principle has become, some say, part of international customary law, or part of international treaty, or part of international law itself. And this is direct bearing on Article 51 of the Indian Constitution. Direct the principle which says we shall have respect for international law. When something becomes part of international law, and you are interpreting a statute or SL to respect international law, is Part 4 binding on courts? That's a very important question. Part 4 is explicitly defines the word state to include the legislature, Article 37. And look at it. It does not directly apply to court because the whole purpose of directive principle is to take it away from the court. But assuming courts take notice of Article 51 as binding upon them, are they right in that assumption? Being wrong, or they should leave it to a proceeding institution. I don't see any writing on this subject. And people have done their PhDs on directive principles, that's a different matter. PhD does not necessarily equal knowledge. Knowledge comes out of the art of asking questions. And knowledge doesn't come by reading under the carpet and by box office formula of obtaining PhD, by cut and paste. No matter how much you turn it in, a PhD is defined by most university statutes as a lofty contribution to knowledge. And that way, tons of books on directive principles, you will find them. Some are my favorite, like Stating, on socialism, rights and the Indian Constitution, very good book. But they don't raise the question which I am raising. Why? I think because my friends and good people, otherwise parents of grandparents, nice people, teachers, good colleagues of mine. If they do not know what questions to ask of opportunity, and you cannot make no danger of making a lofty contribution to the state of knowledge if you don't even know how to ask the right questions. Simply not. And that's not apply to you because, as I said, other people, they are very specialists in other people. Not us, nothing applies to it. Bhagavad Gita has a doctrine, you have heard of it, Nishkam Karma, detest action, and I add Nishkam Ninda. That is stricter. They also detest. You criticize somebody else. Criticize Sasikala, for example. Nishkam. No, I'm not interested in criticizing you. Criticize you or not. The Nishkam Ninda is not a dissertation. Sakam Ninda. You must have points to make. And the point very much depends on the question you ask. So therefore, the trouble with 51 is still unresolved, and I wish you luck if you want to pursue it. Many commentators have noted that this is an indeterminate provision, and that's quite accepted. What was the convention that says, what was the Winfield? Winfield, there are 14 extra Winfield or something, Winfield principles on precautionary principles. And Winfield lays out 14 different versions of the principle. So what each version is, and the question arises whether PP is a moral principle or a legal principle. And I draw attention to this debate started by UNESCO. Just trust. UNESCO has a trust called just, or most. And it has recently defined the moral principle of precaution. Which is essentially a principle which says it is, before it became a legal principle, it is above it. And I won't go into the details. In most, the booklet after recommended for reading from UNESCO, it's hardly 50 pages, published by UNESCO. A lot of difficulty. I think the moral principle is also as indeterminate as the legal principle. And to tell you what the secret, this whole thing arose out of precautionary principle. And there is a debate finally on prevention versus precaution. And there's a lot of discussion on that. I won't take your time. So, सब चलता है. The more you bluff, the better. That is what you're teaching in Yoga. Yoga is an exercise in bluffing, noble art of bluffing. But it arose to let you on a secret on genetically modified food made. And certain countries said, we will not import your junk here. And genetically modified food was produced in US and EU. So it all arose because the principle was severely tested. There is a very beautiful article by Sunstein of Chicago on precautionary principle, which I went through that in your reading in case you look at it. And he says precautionary principle does not do any of the jobs assigned to it by the 14 virtues. So it was a politically very important to argue that we will stop the import of genetic foods in our country. So sometimes precautionary principle has been applied, but it is not applied across the board, like biotech other biotech products like pharmaceutical products. So it's only there to corn and maize that this principle is applied heavily in developing countries. But in regard to other nanotech products or biotech products or other technologies, pharmaceutical products has not been used at all. Because we use drugs which are still under experimentation by U.S. the Federal Drug Department, tested and retested when they are fit for human beings. We use them freely. So, in a sense, some may be a federal sovereignty and most of the time we do not. We do other things. Yeah? We can't be sovereign all the time. When it's wild, when something happens. So that is, I've given the idea of morally unacceptable harm. It's the principle of UNESCO, and that's an important principle. And that is a principle that we will see is used in theories of Anthropocene justice. So you have to link it with concept principles, UNESCO principles, and I use it in the summit here, where the concept principle, I'll give it somewhere. This is used further. Now, it's there, somewhere there. And you say no material. There is there. I'm not used to these things. I'm used to talking without overhead projection and that. Unless some of my students say, we heard the Baxi class of Jurisprudence, very good, very good. And they told it to my wife. She was very keen, She was keen to criticize me and she wanted to have some masala. So she's now sitting in Stanford, Geja Krishnan. And she Geja others can teach jurisprudence. And Geja looked at me and said, Sir, shall I be frank? I said, I always encourage my students to be frank. If they are not frank, they don't exist. It's so bad. And then she said, ma'am, it was very good, but sometimes. Listen to her carefully. This is my home. Said, Geeta, come around, don't hesitate, don't stumble. Then you talk to stumble. I said, doesn't matter. After a while you speak, but speak the truth. I won't go away. He said, sometimes, ma'am, very rarely. But sometimes we all met after jurisprudence class. I said, the external class, that is OHT, overhead transmission. So, OHT is not happening here. I was very pleased because the stuff like this is going on. So, in a sense, the concept principle is an OHT principle. It goes up to the head of the state because it's a very important principle that human activities may lead to morally unacceptable harm. And that's the formula of immense use futility. When you reach the threshold of morally unacceptable harm, action should be taken to avoid or diminish. I like this formulation, and this is very relevant to anthropology. This is very relevant to ambition. This is very relevant to global warming. This is very relevant to climate change. In fact, one of the principles of climate justice that I did not in terms of human rights and environment, which are such as this, and Baxi, which says, the Baxi because it's unreadable, but you must read. That's why our strategy is this principle of avoiding the harm. Just the afternoon somebody came from the faculty to ask for my topic, and I said the right to do a harm, human right to do a human rights harm. And it's what I'm partially working on. So this is the first principle of Anthropocene justice is avoid doing moral harm to other species, to the earth, respect the rights of Mother Earth. at Cochabamba in 2010, there was a Cochabamba Declaration which says the rights of Mother Earth are supreme. In the states of Ecuador and Mexico and many other constitutions, in Brazil, they call it Panchamama. The rights of Mother Earth, which is otherwise an object of science, that she becomes a mother. You don't violate your mother, that's the idea. You're nurtured by her and you pay back to her. That's the idea. The idea of the planet in distress, that the Anthropocene, that the scientific discourse, the planet disappear, extinction is Anthropocene concern. But the First National peoples of their races, the earth, we are the children of the earth. And you must read the Cochabamba Declaration to understand how the declaration develops the right of the earth and is endorsed by General Assembly as a new idea of justice, global justice. All right? I would come. Any comments so far? Yeah.
Last part of the law also revolves around the how to find a best balance between development and protection of environment. And I mean, you also have a sustainable development, that how to sustain the job for our future generation. So why can't we, look into some reform for climate change and light up the problem of civilization? I mean, why are we only looking at the continent
No, I was talking, right. This is one of the problems already been nobody discussed it. I think it's a form of AJ, Anthropocene justice. The second candidate for basic norm is the PC. I think it is indeterminate, it's not bogus, because it leaves it doesn't say anything. But the twist in the tail is it's a moral principle of not avoiding harm. And then you marry it with Cochabamba Declaration, with the rights of the earth as a whole, as a multi-species, that coexist with human, avoid anthropomorphism, and then it becomes richer. And you never know. You turn away and return. You never know when you return to the moral principles which we currently rubbish in international law. You never know when you return to that principle by concept, that the precautionary principle is not a legal principle alone. A legal principle creates no obligation, but ethical principles, it looks different. It's a duty to avoid the harm, which may occur, which does not necessarily causally occur. But in practicing AJ, it occurs, its occurrence is a given. As this was said. So you're right. On the law, you dismiss PP as a grown norm. I would dismiss. But there are certain wanted lawyers who still speak for it. So I leave the field open. This is describing what the potential candidate. Last candidate is sustainable development. Every portion. And when you veer towards that somehow you reconcile sustainability with development. Question is very simple in two words. Can you reconcile the business with sustainability? Can you reconcile culture with sustainability? Nehru was against Kumbh Mela. Maybe 14 years of Mahakumbh continuing. Think of the river. Of course, Heraclitus, the great Greek philosopher, is supposed to have said, you can't dip into this water from the same river twice. A river is, by definition, flowing. And therefore atoms and molecules change every second. Like a face. Your face is changing every moment. Some portions die, some are reborn. There is no such thing as river, according to Heraclitus. Authentic. Is a talk, I think, in constitutional identity. If you apply Heraclitus' notion of change, then how does the concept of sustainability appear? So you must have a theory of social change in order to have a theory of development and a theory of sustainability of development. But let us go step by step this time. You will tell me when 10 minutes, Amita, then I have to wind up. Then just wind up. Until then, I'll complete this discussion on sustainable development. Correct. ST is another chemical. It emerged, as you know, now in 1987, in the Gro Brundtland report to the Prime Minister of Norway, and she included this idea of sustainable development. And she was the first, the report called Our Common Future was the first to talk of many generations, the intergenerational justice was embedded in the idea of such ST. The ST is not a matter of one generation, but of two generations. And intergenerational justice is broad. Intergenerational is broadly applied to civil society as well as state. It does only apply to state. But I think, and I have a quotation from her, which is somewhere here. That's what. You develop the sustainability is one of compromise. To my mind, I mean, Justice Kaju's word is rubbish. He writes judgment, so this is rubbish. So, Justice Kaju was very angry with me. In Bangalore, I spoke about him and his contributions to jurisprudence. And I said, India has long waited for a school of jurisprudence, and Justice Kaju has got one. And it to be called in English as Kachuda jurisprudence. That's what the Kaju means in English. So Kashmir jurisprudence is rubbish. It cannot develop ability of future generation to be judged. The great problem in the idea is rubbish. You make it constitutional. They said it on the bench. It's nonsense. This is not about nonsense. It uses constitution. It's absolute nonsense. And logically, nonsense is that which cannot make any sense. Because it does not obey the law of contradiction, non-contradiction. Instead, the sun rises in the west and sun sets in the west. You can't notice the sun rising and setting in the west. So that is impossible. You make it possible by nonsense. That's what I think sustainable development does. I'm sorry if you have a different view, you are welcome any time to say it. Because you... No, but please, I think I speak too loud. Can you hear me now? So it is a basis for the recording, no? Oh, I'm very convinced. I'm sorry. I thought there was something to say in favor of sustainable. I'm not even begun. But it seems to me to say meets the needs of the present without compromising the ability of future generations. How many generations is future generations? On which Brundtland's report is obviously silent. John Rawls did not achieve intergenerational justice, but he attended to it because he was concerned with justification of inequality as a principle of justice. And therefore he says somewhere in his big book called The Theory of Justice, I forget the page number now, but he said it clearly. He said affirmative action against racial discrimination should be 3 generations. Mother, grandmother, mother and daughter. Now he didn't say, he said godfather, father, and the way you count generation, you have to be feminized, everything has to be feminized. How many things you have to feminize? Religion. You don't have life enough to feminize everything. But you must continue to feminize. So, granddaughter, daughter, grandmother, 3 generations. And he said that is a tolerable, that's more than what human being can comprehend. There was a man called Thomas Jefferson who said the Constitution must be rewritten every generation. You can't have a Constitution before you were born binding you today. You can't have laws of penal code and these codes were written in 19th century. I had a Soviet professor in Soviet Union then existed, he was a professor, and I was the dean of the law school, and he said, would you like to talk? I said, well, certainly covered before all. So I said, I asked my colleagues, and some of them were there, and to a man, I can't feminize it, to a man they said, they're all men, they said, law and social change. That's a favorite of Indians. So he said, oh, very well, can you tell me when did you write your code? I said, we have no code, but we have code. So when was the penal code done? When a procedure code done, civil code, all 18 something have the contract. Then he said, sir, I don't know, but I can only say I'm amazed, I'm not criticizing your country. How can you talk of law and social change when your clothes are so old that that was 980, 81 or so. See, 1981 you followed 1865, 1876. I cannot possibly talk about law and social change. You talk about Soviet law, which he did. So that person's idea was the Constitution goes to your idea of referendum. You must redo your Constitution every 20 years, every generation. Cannot bind it. When I was in Hungary, in Budapest, before the so-called revolution occurred, the communist society, yeah. Louder, I can't hear you. What did he say? Yeah. I don't want to enter into discussion of Jefferson and what he exactly said, but you're right. What makes a principle a core principle? Is the pursuit of happiness a core principle, or is life and liberty? The American is the only constitution which in Declaration of Independence talked about life, liberty and pursuit of happiness. No constitution of the world talks about happiness of the state or the people. The American Constitution does. So what are the core principles? The question, which the later generation is to follow. It's liberty, equality, life, liberty. What does life mean? Gun control or no gun control? Because you can suffer up to life by reproductive abortion or reproductive rights of women or man dominating the embryo. This is a number of questions. So what the argument against that person ultimately prevailed. We set Constitution as core principles and leave it to the unfolding. So I distinguish between change in Constitution and change of Constitution. If you can make changes in the Constitution, you don't have to have a debate the fundamental principles on which the Constitution lays. But if you want to have change of Constitution, and Justice Beketala and Sir Abdi and others had a committee in some Prime Minister's time of the central government, which were asked by pipeline, which were asked to ask whether the Constitution needs an overhaul. And they, after 2 years, they came to a conclusion that the Constitution does not need fundamental change. It needs changes in the Constitution, but there is no of the Constitution. Speaking, and this is not the subject matter for discussion, but it's a great matter, juristically, legally, you can, Keshwalner and since Keshwalner, you can change the Constitution, you have change of the Constitution, provided you don't violate basic structure and essential features. When I'm asked how is my health, I say, I reply in the language of the Keshwalner, my essential features are upside down, but my basic structure is up. So my health is good. Because the court, and essentially the difference, you have to understand the difference between essential features and basic. I say it is basic structure that matters. And basic structure is, I compare Keshwalner with a constitutional strip case. So they said one government after another, then it came to the setting of the last government, put their hand, and this is ours. What was that government? Judicial review. You can do anything you like with the Constitution, provided you don't touch judicial review. Which is what is judicial review? A power to interpret the constitutional word. So, basic structure is there. Regardless of what Khanna said, what this man said, that man said, you study the evolution of the basic structure and you come to the same conclusion. So, legally speaking, in India, a change of the constitution can only come about by revolution. It cannot come about by Parliament amending it under 368. Because 368 said, Palkewala got the argument right for a change. And now he argued with the Supreme Court that 368 article speaks about something called the Constitution. You may change it, but you cannot change it without recognition. Because you have amended this Constitution. He concentrated on the word, only one word, this Constitution. What is this Constitution? Yeah. That is like this. So they said this Constitution is basic structure. Then you said, what is the basic structure? My story is, basic structure is what we, the judges, say it is. By virtue of what? By virtue of judicial power. बाकी इससे सुप्रीम बात है तो सब कहेगा executive legislature, NJAC for this side or that side. They say for this side of basic system. Take your judicial review. Appointment हम ही करेंगे, आप नहीं करेंगे. Basic. Whether two decisions, whether the proclamations of the presidential rule, Arunachal and Uttarakhand, violate the basic court said yes. You can't do president's rule, you have protest. Because Bombay said so. You know, that's true. What is basic structure is what the judges do with what they say. Essential features are बदलते रहो. So a parliament has plenary power. Parliament can bring another NJAC bill and do another constitutional amendment, provided the primacy of the court, the judges is preserved. That's the message of NJAC. And why can't you do it? If you don't do it, what does it mean? That you want executive to appoint the judges. And who are you? You are the biggest threat to them reforming. How can you have the power to do? But people won't read the judgment. The bad habit I have. People don't think their opinion. So this NJSC is wrong. I review for UP, a whole book criticizing the NJSC. It is published, I'm sure. And he says that the Salabester wrote, one fellow says, wrote Dissent of all ages. Believe you me, he did no such thing. It's a very poor dissent. Juristically very poor. Politically I am not so. So, very, very sustainable development. My goodness. The question is, how many generations? Anthropocene injustice, as will be discussed, it does not deal with 3 generations. It deals with infinite generations. Generations upon generations, take next 100 years, 4 or 5. Next 2 days. There is a dislocation between geological time and legal time. We talked about calendars yesterday. Yesterday we talked about geography of law and geography of Anthropocene. So you took necessarily talk about many generations, not one. And that's different from ST. And then I should hurry. Of course, ST has been adopted by many instruments that you have passed and reiterated a number of times. It's considered to be a soft law, a good norm of and law, environmental law. I want to think about some central concerns, and I'll end with that. There's a man called Bruno Latour. Bruno Latour wrote several books on politics and environment. You must read Bruno Latour. He wrote a book, which is a very interesting book, Latour on beware never modern. Setting of idea. How medieval they are. They're extraordinary book. It's difficult to summarize. We must read Politics of Environment is a great book. And somewhere in that book, Latour says there are 2 concerns. One is matters of fact, and second is the matters of concern. Concern. Or when do the matters of fact become matters of concern? That is the real question. Most of the world today lives as if Anthropocene has not happened, or can be averted. It's no concern on that. No concern. Gardner says, the article, you can admit if you are poor as much as you like. You can burn an ozone hole if you like, if you are poor. Is that acceptable? Is that sustainable development? So it is how does sustainability translate matters of fact into matters of concern? It's a very big question, which I indicate, but not. I've given you an article by Louis Coetzee, I think familiar, it's a long quotation. And I want you to look at the long quotation fairly carefully. It makes 3 or 4 points against sustainable development. First point it makes is about global ecological crisis and resource scarcity. How do you arrive at a formulation of that which is sustainable in moments of crisis? Yeah. And then he says population is not a resource. Be right or be wrong told you, but it's wrong. Another philosophy of sustainability is based on false assumptions. For example, it accepts as correct the fact that humans are capable of assuming how much ecological capital they need. Now, that's the same idea. How do we know what the future generations may want? How do we know what our daughters want or need? Is it for the grandmother to decide? Does she know enough about the granddaughter? Does the mother know enough about the granddaughter? And do we know about great-granddaughters and so on and so on in the scheme of time? What? My granddaughter uses Twitter and Facebook. I don't use it, so I don't exist for her. All her friends in school use Twitter and Facebook, social media. And my grandson uses video games. They have virtually no use for me. Future generation, the entire have no use for the prior generations and their wisdom. And the trick is how to speak environment to all people. How to bring in, Locke did it in his way, which became the first biodiversity movement, that you must conserve enough for the future for the future generation. Wise use, American environmental law developed out of American doctrine, the early part of last century, 15th century. It developed by the notion of wise use of resources. The Aboriginal people talk about rights of Mother Earth and wise stewardship of natural resources. Not sovereignty, stewardship. Not sustainability, stewardship. A stewardship is a different kettle of fish altogether than sovereignty. There's different ideas there. So, there is the third point. You assume that the earth is stable, but Anthropocene teaches you otherwise. There is no such thing as sustainability. The earth is in abrupt, dangerous cycle of changes and rechanges. And even if you do geoengineering to arrest climate change, you are charting into an unknown environmental territory. It can only be experimented. It can only last for half a generation or one generation. You do not know the consequences of making new holes in the ozone. Each one will bear the solar radiation method of geoengineering. It's very, very uncertain. Unintended consequences of scientific research. So, in a sense, Coetzee we give 3 or 4 reasons on sustainability. I think we say with all that can be said in favor of sustainable development, conceptually it is vacant. There is no concept on which it bases its slogan, flag waving, is very important. Have you waved flags? Anybody? Flags? I went marching in Euston Square in London, waving a flag, no aggression against Iraq. No war in Iraq. Till my hands fell off. 2 hours. Absolutely no effect. Aggression did happen, plunder did happen, loot did happen, suffering did happen. Nothing. So, flag waving is still important in one life. You don't have it, you don't have anything. He took that chance and he failed. He took that opportunity and he failed. But not taking the opportunity is sustainable development. Not taking of it. When you put the environmental logic, they don't have sustainable development. They have instead sustainable degrowth. As we saw yesterday. Not development. So development means you will exploit the earth resources for your own betterment. You build more flyovers, you will build more monorails, you will build smart cities, you will go cashless, right? And you will do everything. That will cost in nature a great deal, but it's development. Sabka साथ, सबका विकास. Let no person be left behind. Everybody. So, we are thinking like a mob. Yesterday's thing. How do we attain sustainable degrowth? Now that makes sense against sustainable development. The idea is hurry slowly, but cut your dependence on fossil fuel. This lasts for indeterminate period in the atmosphere. Create smog, create all kinds of consequences for humanity. So you do somehow reduce the rate of emissions. You build a theory of just emissions, whatever that be. And as I said yesterday, you don't grow for the sake of growth. You grow. Bhopal, not Bhopal, sorry, Bhutan. Bhutan, king developed this idea, which is called Defense of the West, called not GNP or GDP, but Gross Happiness Index. Happiness he got from the US, pursuit of happiness. You might have all the rights, but you might be all right. Now they say, how do you think of right? Right? And lawyers, when the class of lawyers say duty. What is the other? Duty. Hopefield said the other of right is no right. No right of yours is violated. That's what they claim in Bhopal. That's what Monsanto claims. Bhopal must suicide. In India, I said. Then there's the third, right and left. That's the direction. Ideological all of that. And fourth is right and all right. You have all the rights, but you must be all right. That is the Bhutan's idea. That's it. Growth, happiness. Happiness also consists in having rights, or exercising rights, or surrendering rights. That's the idea. Whether it's good or bad, I don't want to go into it. So, in a sense, and I end with this point because I don't go on, I'll take a question. My last sentiment is borrowed from a great economist called Joseph Schumpeter. And Schumpeter in his big book talked about capitalism. How did capitalism arise? A very good book still, wrote in 30s of last century, but it's still worth reading, even if you're not an economist. Schumpeter spoke about what he called, and I quote him, creative destruction. Destruction becomes creative. It's a lot better concept than sustainable development. Now, sustainable development did have things like conservatism and biodiversity and all that. But anything that falls foul of that is not sustainable development. There are some good takeaways from the idea of sustainable development, but not too many. As far as the real enemy of climate is global capitalism. And how does environmental law get rid of capitalism? In a famous statement, Mohandas Gandhi said, there is enough for everybody's need, but there is not enough for everybody's greed. Fantastic statement, come to think of it. Post-Anthropocene. There is enough. You can sustain yourself very well in the hut. 75% of the richer sections of society are doing just that. You can sustain yourself by electricity. It's only now that this cashless society and computers are very well, they require electricity. For electricity requires dams. You need to fell for dams, you need to fell forests, you need to displace water. Just imagine beyond 3 generations. So great grandparents, how did they live? Just imagine Karma. How do you produce the fibers of capital? There is no Xerox, there is no computer, there is no stencil, there is no Viro. He dipped a pen, a huge pen with ink and wrote. There was scholarship before. I mean, a matchless scholarship. Right. Matchless, fearless. The whole world was transformed as a result of what we said to our economy. So there is the possibility of going back. Sustainable development goes forward and makes development more sugar-coated. And in process of sugar-coating it, more sustainable, more friendly to the environment, more friendly to people. In effect, it immeasurizes the people. 50% or 60%, we talked about land bill and all that, whose land is taken away. So I would say that the problem of anthropocene justice is not sustainable development, but how to prevent creative destruction that is rampant in the name of development. You destroy livelihoods of people, you destroy climate. You think of Delhi and when there was ring road, very good. But you think of how many millions of people you push into margins of existence to a building like this, where I'm talking. So that creativity, and but another expression called days of creative destruction. You need days of creative. So earlier forms of industrial capital there, industrial revolution were crudely destructive. The modern forms are more subtly destructive. Post-Fordist, globalization and all that. And I end by saying a saying, a very beautiful book which you must read when you have the time. It's not on environment. It is written by my favorite thinker who writes every 10 years. Doesn't write English, called David Harvey, the great geographer, but a Marxist geographer. And David Harvey's last book is called 17 Contradictions of Capitalism. Capitalism, after Marx, is to be understood the way I call Marx and Marx. It's not a mere matter of opinion, a matter of structures, institutions. It's hard work to understand what it is, how it is done. And Harvey talks of many types of contradiction. There are 3 types of contradiction. One was structural contradiction between capital and labor. The other he called moving contradiction, which is like sustainable development, something for everybody. Some trees, some river, and lots of flyovers, lots of new airports, lots of dispossession is a sentiment. Lots of capital accumulation goes hand in hand with dispossession. There are moving contradictions like equality, liberty. And then there are universal contradictions, there are the 3. And I end with one of the 3. One of the universal contradictions is universal alienation. You're dissatisfied with the life you and your friends lead. You're dissatisfied with the world of objects. You're dissatisfied with globalization. You're dissatisfied with governance. Looking for something else. I don't know what you look for in Nalsar youth. I suppose you look for new clothes or new music. I don't know what new. Tell me. But I think universal alienation arose with the nuclear weapon, with Hiroshima and Nagasaki. And it continues with Anthropocene. The world is out of date ever since 1950. Whether legal or not legal, what have we do? We fought a long battle and WHO sought advisory opinion. These aftermath, it is so high, some of us drafted the complaint before the war call, saying WHO should seek advisory opinion that nuclear weapons are unlawful. And the WHO is a specialized agency of the UN. So that's the international organization. And WHO was ultimately persuaded to take this case to to the ICJ. And a stunning judgment, dissenting judgment of my friend, Justice Christy Piramantri from Sri Lanka. You must read that, even if you don't have the time. And this strong thing you must read. Just as you must read the heart-rending dissent in Tokyo trial by Rabindranath Pal. Justice Rabindranath Pal was the Indian judge in Tokyo trial. If you have not read this, you have not read law. As simple as that. You might have decreed. That's a different matter. But therefore, we live under the umbrella of weapons of mass destruction. So we alienated, whether we know it or not. And we live in Anthropocene. The question of development, sustainable development, or creative destruction is how to overcome this sense of powerlessness, this sense of dispossession, and how to restore a sense of wonder and engagement with the world, the enchantment of the world. How to do that is the main question, I think, of environmental law as we know it and as we should develop. Enough. I should say enough for them. Enough until the day, as Krishna I used to say, enough until the day, enough until the day is the evil thereof. So I have spawned a lot of evil. I apologize for that. Oh, I don't apologize. No. He said it wonderful. So I've been told that word. But I've taken a lot of your time. If there are any comments, I'll circulate these notes by tomorrow. You will have the email, so I'll send it to you. And also tomorrow's class, whatever it is, I won't detain you on that. We'll discuss, I think, what is it tomorrow? Precautionary. Yeah, it's very good. So kindly do read the required reading at least, it will save time.